the top 7 kinds of evidence that will help you win in small claims court coming up right after this.
Yes.
Hey everyone, welcome back to the Mr. Small Claims Court YouTube channel. Very grateful to have you. I'm Jordan Farkas, and if you are a returning subscriber, thank you very much for subscribing and coming back to the channel. If this is your first time on one of my videos and you haven't yet subscribed, please hit that subscribe button and the notification bell so that you don't miss a future video that can help you win in small claims court. Obviously helps me to continue to produce videos just like this. If you want to learn more about me, you can check out my bio video on the homepage of the Mr. Small Claims Court YouTube channel. Of course, don't forget to like the video as well. Share it with anybody who you know is going through a small claims court process. With all that out of the way, let's get into the subject at hand, which is the top 7 means of evidence that will help you win in small claims court. And one of the things that inspired me to do this video is that, first of all, I talk a lot in my videos about evidence. So it made sense to me to kind of go take a deeper dive, if you will, into what makes for good evidence. And also, I talked about in my last video, the last one I recorded, which was video 14, I talked about the idea of coming to small claims court with receipts, i.e. having means to prove your case. Because if you don't have any way of supporting what it is you're telling the judge, then your chances of winning are that much slimmer. As well, I've been noticing in YouTube comments that a lot of people seem to have questions about evidence and specific questions about the types of evidence that they have. So I figured that's a topic that's on a lot of people's minds, people that are dealing with small claims court issues, and why not do a video on it? Okay, so as usual, I have prepared my usual old school whiteboard here. The last video, I went through another video from another channel and shared my screen. That was a bit of a different change, and I look forward to doing that again. The audio didn't come out wonderfully. I did link to that video, by the way, in that in my YouTube posting of that. That's again video 14. So if you didn't get a good hearing of the video that I was sharing my screen with, you can actually link to the actual video. That was the tips from a small claims court judge. In any case, I digress, and today's video is on the 7 kinds of evidence that will help you win in small claims court. So the first one I've noted down, I tried to actually go in order of what I feel to be are the strongest forms of evidence down to the weakest. Of course, it will depend on the strength of the particular evidence in your case. So there's no kind of one size fits all, but this is generally my feelings based on my years of experience when I did practice as a small claims court lawyer as to what I think are the best forms of evidence for the average small claims court case. Okay, number 1 I have here is a contract. Okay, it is so important, particularly if you're a business owner and you're entering into a contract, let's say with a homeowner. That's the type of example I've used in many videos before, where you're a landscape person, you have a landscaping business, and you got into a contract with a homeowner and the homeowner hasn't paid you. It's so important for you, particularly as a business owner, to have a contract. If you're not a business owner and you're just an individual person who has a small claims court issue, then of course it may not be within your control to have a contract. But for many, many cases, it will involve the ability to have a contract, meaning oftentimes people are coming to court precisely because they didn't have a contract in the first place. And because of that, the dispute arose, and it's very hard for the judge to make sense of what transpired and who is the right party. So you can actually avoid even getting to small claims court in the first place by having a very well-written and strongly drafted contract. I will talk about contracts in a future video because there are certain clauses that you should include in a contract that will help you win your small claims court, but that's beyond the scope of this video. But the point is that by having a contract, if you had one and you don't, you may have actually even have avoided small claims court. But let's say we're talking about a case for the purpose of this video where you did have a contract, and unfortunately the person who you contracted with has not lived up to their side of the bargain, and here you are in small claims court. So of course you're going to want to present that contract for the judge. A lot of these tips and suggestions that I'm going to talk about, particularly in this video, may sound obvious to you, and if it does, congratulations to you. That does mean that you generally have common sense, and therefore, because you have common sense, it sounds obvious. But for a lot of you out there, and this is not being judgmental for those who don't find this obvious, it doesn't mean you don't have common sense. It just means that sometimes you can kind of mistake the forest for the trees, or is it mistaking the trees for the forest? Where I think it's mistaking the forest for the trees, whereby you kind of get so tied up in your case that you forget the most obvious thing, which is the starting point, i.e. the contract. I remember a law professor that I had once in a class who used to call contracts the Bible, so to speak, right? Really, it's the starting point of understanding the relationship between two parties, or more than two parties in many cases. So if you've had a contract with somebody and the deal has gone awry, or there's a dispute, then obviously you want to bring that contract to a small claims court. Hopefully the contract was well worded and really presents your side well. If it doesn't, again, that's something you want to deal with for future contracts that you enter into, where you make sure that things are clear. Of course, again, if you are a layperson or an individual, you may be dealing with a contract that was very pro forma or standard wording. Like, let's say you're dealing with a car rental agency where you didn't really have a lot of control into the contract, and it may not be something that's helpful to you in this instance. So you have to kind of use your judgment. You don't necessarily want to rely on it, but I'm talking about cases where you yourself were involved in the making of the contract and that contract was breached. The person did not live up to their side of the bargain. So that's the starting point for what you want to bring to the court, because the judge will really give that a lot of weight. If the judge sees, let's say in the case of a landscape business, that you have a landscape business and you did that work for the homeowner, the judge is going to want to see, is going to want to know, was there a contract between the parties and what did the contract say? And again, hopefully your contract is well written such that you definitely set out the expectations, what the price was, the timing of delivery, et cetera, et cetera. And by doing so, when you come to small claims court making a claim, you're in that much of a better position to rely on that contract as really the formidable document that you should show to the judge to help you win your case. So that's the first really strong type of evidence that you can have in a small claims court proceeding. The next one I have on this list is an invoice. Okay, now invoices are very important. Again, not every case is going to involve an invoice. Forgive me if I keep repeating myself, because every case is so dynamic. So some cases there won't be invoices involved, right? Some cases are a simple kind of neighborhood dispute where things go run afoul between neighbors. So not everything involves invoices, but again, taking, the average type of case where you do have a business and you did work for somebody and the person hasn't paid you, then you're definitely going to want to send out an invoice. Again, this may sound obvious, but you'd be amazed at how many people are relying on handshake agreements to run their businesses, and they're not prepared for when something does go afoul and they have nothing to show that they actually tried to get paid. It's very important for a judge to see that you actually made efforts to get paid from the person who hasn't paid you. So sending out an invoice will help you demonstrate what it is that you're owed in terms of the amount and why you're owed the money. Of course, in and of itself, an invoice is not proof per se that you did the work and that you deserve to be paid for it. Of course, that doesn't mean anything. Anybody could just send an invoice to anybody and say, oh, I want to get paid because I sent you an invoice. Of course, you have to have performed the work. But again, by having that paper trail for the judge to see that there was a contract and there was an invoice sent out and there's no proof by the other party that it was paid, it's really it's helping you mold your case and put it together so that the judge has a clearer and clearer picture of what transpired between the two of you. It also shows the chronology, because hopefully your invoice has a date on it, so you can really demonstrate the chronology of what transpired and when between the parties. And again, there's all sorts of things that invoices should include. It should set out the work that was done. In some places, it depends on what jurisdiction you're watching this in, but in some places there are various laws that detail what must be included in an invoice, or even what must be included in a contract. So if you are preparing a contract if you're watching this and you're saying to yourself, I wish I had that, but I don't have that right now, and you want to fortify yourself against a future lawsuit, definitely you should look into, I would recommend getting a lawyer involved to help you draft that contract and make sure that your invoices and all your documents are in compliance with the local laws. But in the very least, if you are the kind of do-it-yourselfer, make sure that you're complying with the local laws of your jurisdiction. And oftentimes, even things such as invoices are dictated by the law. In Ontario, for example, where I practice as a small claims court lawyer, Ontario, Canada, there were all sorts of consumer protection laws in place that dealt with even things such as invoicing, in terms of detailing what you have to detail in an invoice, how much you charge, what it is you're charging, not how much you charge like it's dictating how much you have to charge, but setting out what it is that you're charging for in particularity. And there's a lot of consumer protection laws that apply in different jurisdictions around the world. So it wouldn't surprise me if you're in a jurisdiction that does have those requirements. So you should bear that in mind. But again, the point of this video is not about preparing for the future. It's about what you have now. So if you have an invoice in your possession that you sent out to the defendant, then it would be great to have that with you in court. Also important, by the way, is proof that you delivered that invoice. Okay. So, nowadays we don't really do registered mail. People still are doing that, but for the most part, you're going to be delivering your invoice probably electronically. So you want to show that the invoice was sent electronically. So not only do you want to bring the invoice, you also want to bring, let's say, proof of transmission of that invoice. So if you sent it by email or by text message, you want to bring that accompanying text message or the digital email where you sent the invoice, however you sent it, to show that it was actually sent and delivered to the defendant. So don't forget that. That's a very important component, especially if the defendant tries to claim that they never got the invoice. Now, the next on my list I put down here is email. Okay, number 3 on the list is email. And emails can become very important once again because you're demonstrating a paper trail between you and the person that you're suing. Of course, it's very important that your emails really tell the story. And I talked about it a bit in an earlier video. In fact, I'm going to be doing a future video about what I call writing for the judge, meaning when you're sending out emails, as you start to realize that, hey, I may be getting stiffed over here, because usually you get that gut instincts, or usually the person tells you straight out, I'm not going to pay you. Then as soon as you know that's happening, you want to continue to build your case and prepare a paper trail. And a great way of doing that is by sending out an email. It doesn't mean the email should be filled with all sorts of vitriol and attacks and emotional elements. Remember, I talked about in the last video about leaving your emotions at the door. You want to leave your emotions even as the case is coming to a halt, even as you're starting to get into a dispute with somebody. I know that's easier said than done. I'm not saying you shouldn't have emotions, but certainly when you're preparing your case and you're thinking to yourself, I'm going to send an email to this person who owes me the money, try and think of who may be reading it in the future, particularly a judge. Nobody ever thinks that they're going to one day wind up in small claims court. Nobody wants to be there. But the fact is, as you can see, the fact that you're watching this video, there's a good chance that you are dealing with a small claims court lawsuit. It does happen. It's happened for me, both as not only as a lawyer, but also even in my personal life, dealing with a small claims court issue. So I don't know what the statistics are on this, but I wouldn't be surprised if, I don't want to put a number out, but the average person probably has been to small claims court one time or another. Maybe that's not true. Maybe most people have never been to small claims court, but many, many people have been, as demonstrated by the amount of people that are watching videos such as these. So the point is that you definitely want to make sure that when you're sending emails to the person who's in the process of screwing you over, if you will, that those emails really tell the story. It shouldn't look too manufactured or processed. It should come across as natural as possible, but definitely make sure that if you have emails that you sent, you want to bring those to court so that you can show to the judge, again, showing the chronology of when you made demands for payment, of how you sent various items to the person who you're suing and why that person hasn't paid you, et cetera, et cetera. Emails can do a very good job of telling that story. The next item on my list here, number 4, is photographs. Okay, so obviously very common in this day and age, when things go badly, people will take photos. So to use the example I've used before in terms of doing landscaping work for a homeowner, you certainly want to take photographs so that you can demonstrate what transpired, and you want to bring those photographs to the court. Now, it's very important, again, like I talked about showing proof of delivering the invoice, you want to show proof of when you took the photographs, because otherwise they're just kind of standalone photographs without really telling the story of when, where, how, etc. So if you're taking photographs, make sure that you have a good means of knowing, of being able rather to show when the photographs were taken. So if you're doing a landscaping job, you want to take before photographs. Okay, so take photographs beforehand and then maybe email them to yourself so that you have a good paper trail as to when the photographs were taken. Maybe you have that automatically on your camera, assuming you're using a smartphone to take photographs these days, whatever the case may be. But you want to make sure that you have a means of demonstrating to the judge when it is that you took the photos so that you can show that, in fact, these are indeed before photos, because you'd be amazed at how many people contest photographs. Okay, so it's very important to show when you took the photographs and also who took the photographs. So if it's somebody else who's taking the photographs, then just be sure, this video isn't talking about witness testimony, but that's obviously another very important form of evidence, which is which witnesses you're going to have. If you do have somebody else take photographs, let's say you have an employee, then make sure that that person is the type of person who's going to be available to testify for you if it does get to small claims court, and can testify that they are the ones who took the photographs and the date that they took the photographs. Okay, so having photographs is great, but having photographs in and of themselves isn't necessarily foolproof. You want to make sure you kind of fortify all the important information surrounding those photographs, not the least of which is the date in which they were taken. Okay. By the way, you may have a case where the defendant is disputing the accuracy or the validity of a photograph. And I don't want to get too far down the rabbit hole, but sometimes you may need an expert that can testify that these photographs are genuine, whether or not they're genuine. Sometimes, again, small claims court is a people's court, so it's usually not as fancy or formal as that. Usually you don't really need an expert to get involved. But I did see one person comment on one of the videos about the fact that his photographs were actually disputed by the judge. So be prepared for that eventuality. You definitely want to have some sort of corroborating evidence that these are, legitimate photographs that you're submitting to the court and that they weren't doctored or photoshopped in any way, because that's obviously something that somebody may try and claim against you when you're relying on photographs. Now, the next item I have on the list as number 5 is text. Okay, so I alluded to that before. Text messages are obviously in this day and age a very important part of evidence. And don't forget that a lot of times people forget that. They have all sorts of texts going on all day. People are texting back and forth to a million different people, and they could even forget to realize that, hey, this is something that I could rely upon in court. So again, if you find that obvious, then good on you that you're thinking clearly, but not everybody is. And that's why I wanted to make sure that it's something I mentioned here, that if you have a good text message that can help your case, make sure that you have a way of submitting that to court so that you can prove your case. Again, you have to prepare for the eventuality or the potential eventuality of somebody contesting the legitimacy of the text message rather. So you want to get that off your phone and be able to demonstrate that this actually came from your phone. I'm not a tech genius, as you can see from the quality of these video recordings and the sound. Technology is not my forte, but certainly try and be mindful of that. So any way in which you can show that these text messages came from your phone, you're going to want to demonstrate that. Oftentimes, if you're in a jurisdiction where you have to kind of list your evidence in advance because you have to provide it to the other side. Some small claims court, you just walk in with your evidence. But if you're in a jurisdiction where you have to provide that to the other side, you may also want to make it clear that not only are you relying on text messages that you've actually gotten off your phone and printed out, you may say that I'm relying on my actual phone. I'm going to show that these are text messages that came from your phone. Okay, the judge may even want to see your actual phone to be satisfied that the judge believes that these are real, legitimate text messages. So again, it's the same theme as I mentioned with photos. Always bear in mind that it's not just the actual evidence, but also the surrounding details and data that you may need in order to prove that these are genuine. If you ever watch court TV or any sort of criminal proceedings that are often, on YouTube or, on television or whatever the case may be, oftentimes you'll see that even for things as simple as text messages, they get in all sorts of experts to show the legitimacy of it. Otherwise, they have trouble proving that it's authentic and genuine. And again, small claims court is a people's court. It's not as fancy, but the fact is that people do challenge these things all the time. So it's important to be mindful of that. Number 6 on my list is audio visual. And by the way, the reason I have this so low down is because even though we are in 2024, as I record this, almost 2025, it's December 2024. The fact is that it's not always so wonderful to be relying on voice recordings or videos that you've taken. People love to do that these days, this day and age, especially on their smartphones. People are taking videos of everything. You see people getting into road rage. They're videoing with their phones. And certainly it's something that, as far as I know, you can rely on it in any court, but still it's not always so easy. Sometimes it's very awkward. Technology has to be set up in the courtroom in order to view it or to listen to it. Not every judge has a lot of patience for it, at least as of the date of this recording. So again, I'm not saying you shouldn't rely on audio visual types of evidence, but it's not always the most ideal type of evidence that you think it is. Sometimes it could be great. Obviously, if you're in the moment and somebody's car, you watch somebody's car hit yours, then great. For sure, you shouldn't hesitate to whip out your phone and take a video of it. I'm not suggesting it can't be something that's helpful. I just put it lower down on the list because I do find, like I said, sometimes it does get a bit bogged down when it comes to actually relying upon it in court. But certainly it is something to be mindful of something that can really help you prove your case and be a good source of evidence. And that's why it's on the list. If it wasn't any source of evidence at all, I wouldn't have even put it on my list. But that's the reason why I put it lower down. And finally, I wrote down here for number 7, expert. Okay, so having an expert report can be very helpful. Again, I've gone through this in earlier videos. In the case of, you're a landscaper and you did work for the homeowner, let's say the homeowner is claiming that the work you did was shoddy and unworkmanlike, then don't forget the ability to get an independent expert, let's say an engineer, or whatever the case may be, who can testify on your behalf that the work actually was excellently done and really helped the homeowner and actually improved the homeowner's property value. That's another type of expert. You can have a real estate appraisal, right? You can have a real estate expert who can say that the property value of the homeowner went up as a result of your work. You may have two of these expert reports in conjunction. So you definitely should be mindful of the fact that oftentimes if there is a dispute, you may want to get an independent person who can be qualified as an expert to prepare a report for you so that you can submit that report for the use in court in small claims court trials. Obviously, it depends on the amount of your claim. If your lawsuit is $100, then you're probably not going to be spending that money on an expert. Experts are obviously a lot more expensive than that by and large. But if you are in a case, Ontario, as I mentioned, is a $25,000 limit as of this recording. Some courts are thousands of dollars. It really depends on what jurisdiction you're in. But the point is that oftentimes it can be worth your while to get such an expert report. In fact, in many courts, you can actually ask for reimbursement. If you do win, you can ask for reimbursement of these sort of expenses. That doesn't mean you should go and throw away tens of thousands of dollars on an expert because you'll get that back. No, there's usually limitations on how much you can claim back as part of your judgment, but still, sometimes it can definitely help put you over the top to win your case. So be mindful of the fact that you can get expert reports. If you are going to rely on an expert, make sure those experts' credentials are, I want to say bulletproof. Obviously, nobody's foolproof. There's obviously ways that a skilled person can try and pick apart your expert, but definitely you want to have a look at the person's resume, get a sense of why this person is an expert. Don't just take their word for it, because in fact, if you are going to rely upon them as an expert in small claims court, you're going to have to satisfy the judge that the person actually is an expert. Okay, so if you have a dispute over landscaping and you get an engineer and the person graduated college the day before, that's not exactly going to be somebody who the judge is going to give any weight to, give significant weight to their evidence, if any at all. So you want to make sure that the person actually has good credentials that qualifies them as being an expert. And you also want to make sure that this is the type of person who can be available to testify, because in some small claims courts, you can rely on an expert report on its own, just the document. But in most small claims courts, at least as far as I know, you actually have to have the expert come and testify as well as to the report that expert prepared. So make sure if you're getting an expert that you don't just get that report, you also make sure that the expert is somebody who is willing to testify in court for you if the need arises. Again, assuming you're in a jurisdiction where it is something that is allowed, because different small claims courts have different rules, of course. Okay, so let's just do a quick summary of the 7 types of evidence that I talked about. Number 1 on the list was the contract. If you're not in the habit of making contracts, you should certainly do so, but we're talking about a case where there was a contract, and assuming you were instrumental in preparing it, you definitely want to bring that to court to show that to the judge. It's probably the first document the judge is going to look at. Number 2 on the list is invoices. Okay, you should again be in the practice of sending out invoices if you're a business owner and you find yourself in small claims court. So assuming there is an invoice that you did send, you want to bring that invoice to court to rely on as evidence, as well as proving when the invoice was delivered. You want to show to the judge that you actually delivered the invoice. Number 3 is email evidence. Number 4 is photographic evidence. And again, remembering that you want to be able to show when the photograph was taken and be able to verify the accuracy of the photograph so that if somebody challenges its authenticity, you are well prepared to handle that challenge. Number 5 on the list is text message. Number 6 on the list is audio visual, bearing in mind that, again, audio and visual can be great. There's nothing wrong, unless there's a law, again, in your jurisdiction against it, there's nothing wrong with trying to capture something on audio or visual, but sometimes it can bog down the court. That's why I have it only as number 6 on the list. And number 7 is expert reports. Once again, bearing in mind that you want to make sure the expert has good credentials that can be relied upon and that a judge will give a lot of credibility to, as well as somebody who preferably, I didn't mention this before, but preferably has experience testifying in court, and if not, at least is willing to testify in court, because you may be in a jurisdiction where you have to have the expert not only provide the report, but also testify as to what is contained in the report that expert prepared. So I hope you found that video helpful, and if you have any comments or feedback, always grateful for you to leave that in the comments section below. If you have any questions, again, as the channel is in its infancy, there's more of a likelihood that I will actually see your comment and may even make it the subject of a future video. If not, respond directly in the comments without giving specific legal advice. None of what I'm talking about here is specific legal advice. Everything is sort of general tips and hacks, but your feedback is always welcome. So as are your questions. And of course, once again, if you have not yet subscribed, I'd be grateful if you did that, which will definitely help me continue to make videos like this, but also help you not miss a future video. And don't forget to hit that notification bell, like the video, send it to anybody who you think can benefit from this. And as always, until next time, I look forward to seeing you at the next video. Hey, thanks for watching. If you found that video helpful for winning your small claims court lawsuit, then you're not going to want to miss a future video. Hit the like button, the subscribe button, and the notification bell. It takes a second so that you don't miss a future video to help you win your small claims court lawsuit.